Yes, student. Now we have dealt with section 105 capital A plea of plea bargaining, right? Also, we have said once you've made your plea, whether it's a plea of guilty or not, you also need to make sure that as a presiding officer, you question the accused to make sure that he understands the plea of guilty, because failure to do so will result in the case being set aside, as it was the case in the matter of Figizolo. The citation is 1978, volume 2 SA at page 676. It's a Northern Cape case. So you need to go and have a look at that. It is important to do what? To question, to make sure that here is the person who has pleaded guilty. Does he understand the implications of pleading guilty? Does he know what is it that he is pleading guilty to? Are the elements of the crime all present in his admission, right? Also, what is also important is that after you have done that, then make sure that all these requirements are met, so that your matter is not set aside, right? And also, what we forgot on the plea bargain is that it is very important that any person or an accused who is subject to a plea bargain has to be represented by an attorney. An unrepresented attorney can never enter into a plea bargain. That is very important. Those are the requirements over and above that what we have said. So you need to keep that in mind, right? And another thing, it might happen that since, let us say, in the case of an admission in terms of 112, section 112 of the Criminal Procedure Act, the presiding officer does something which is irregular, or there is an irregular. It could be the presiding officer, or it could be the state that is now the prosecutor, having done anything contrary to what was supposed to be done. Then that case might be declared as irregular, or the sentence set aside and ordered that the case should start de novo. This is what is very important that you need to note. And the case to support that notion of a case starting de novo will be a 1978 case again, and it's Mbutuma. So they've written as Mbotoma, but it's Mbutuma, 1978, volume 2 SA at 530. This is the case that supports the fact that when a sentence or a conviction has been set aside and ordered by a higher court to start de novo, the principle in that Mbotoma case is that you can use the admissions that were done in the first case, in the first trial. You can invoke those to say, but in the trial, in the other trial, the first trial, the accused had admitted to a number of things, and you name them. Those will be admitted as evidence. You cannot say just because it's a new case, then you cannot take what was admitted in that case. So you need to take that into consideration, right? And sometimes, if in the course of questioning of the accused, that is in terms of Section 112 of the criminal procedure, questioning the accused, and it appears that he is not guilty of the offense charged, but that he admits his guilt to a lesser offense. The court should record a plea of not guilty in terms of Section 113. Right? Because a person may say, "Yeah, I'm guilty because there was maybe there was a firearm, and I left the firearm, although it was not my firearm. I left it carelessly. I should have taken it away, and a kid came and shot someone to death. So, and said, I am guilty because I was supposed to take precautions that the gun is not lying around so that anybody can use it." So a person might feel guilty, morally. Sometimes morally you feel that what you have done is morally wrong, and you go to court and you plead guilty. That is when the magistrate must invoke the provisions of Section 113 of the Criminal Procedure Act. Although you are pleading guilty, but the presiding officer will have to record a plea of not guilty, because he can see that you don't understand what you are pleading guilty to. So that is very important, right? That is very important. And another aspect that we need to cover is a situation where the accused says the court has no authority to try him. Let us look at that now. It is very important that the accused should be at all times encouraged to state his version. Sometimes you'll find that somebody goes to court and he just stands there, and the prosecutor doesn't encourage the accused to state his version as to the events leading to the commission of that crime, whether he was guilty or not. So it is important for the court to encourage. That is, now even the presiding officer can do that, but it is important also for the prosecutor, as the person in charge of litigation in a criminal court, to encourage the accused to state his version, so that the court will know exactly. Because another duty which is important is that the prosecutor must also give a summary of the events leading to the commission of the crime, and the summary of what he knows about the crime. So it is important that the prosecutor plays his role and give the court a brief summary of the state's case. If the summary reveals the offense charged, the magistrate is obliged to question the accused. So that's how now you will get the version, because he will say whatever is the prosecutor will state the state case, and the magistrate will then be obliged to ask the accused as to whether he confirms or denies what is being said. Without such summary, the court has no idea of the seriousness of the offense. So that's where it's important for the prosecutor to state the state's version. So the fact that a summary of the offense has been furnished, as well as the contents, must be noted on the record, because it is part of the proceedings in court. That was the principle in the case of Sejake. Sejake is a 1981 case, volume 1 SA, at page 1215. if you look at that case, it's an Orange Free State case. It was stated that that summary by the prosecutor should be entered, should be recorded in court. But then also, and if the accused disputes the details of the state case, the prosecutor will have to tender evidence to prove them. That was what was said in the case of Ngode, which is a 1978 case, volume 1, at page SA at page 309, the Northern Cape case. Also, the same thing applied at the case of Rakanang, 1978 1 SA at page 591. So you look at those cases, and also the case of Sikindi. The case of Sikindi, 1978, volume 1, SA at page 1072. It's a Northern Cape case. Also in the Vetboy case, also 1978, volume 3, SA, page 590. So there's too many cases. If you read one case, then it will lead you to another case. So that was what was said by the court in as far as the prosecutor's role and also the version of the accused, because at all time the accused must be encouraged to state his version or to state something contrary to what the prosecutor is saying, right? Also, it was stated that in nearly all cases it would be far better for the court to hear what the accused has to say with the reference to the charge before inviting the prosecutor to outline the case. So before the case, the prosecutor says anything, it is important to invite the accused. What have you got to say? You are now, charges have been preferred on you, and now tell this court as to how do you explain your involvement in this matter. It is important so that the prosecutor will know exactly where he stands, right? The acceptance of a plea of guilty by the prosecutor is of importance only where the accused plead guilty, not to the offense which he is charged, but to an offense of which he can be convicted on the charge. And the prosecutor does not wish to proceed with the offense charged. If, however, the prosecutor wishes to proceed with the offense charged and therefore does not accept the plea, the presiding judicial officer must note a plea of not guilty, right, and act in terms of Section 115, which is a plea of not guilty. That was the issue in the case of Kundula, 1978, volume 4, SA at page 855. It's a Transvaal case. The wording of Section 112, subsection 1, makes it clear that the prosecutor's acceptance of a plea at the time of pleading is necessary only where an accused pleads guilty, not to the offense charged, but to a lesser offense of which he can, on the charge, be convicted. A person might say, I plead not guilty to capital homicide, but I plead guilty to having driven a car without a license. That's a lesser, it's something like that. And so that is very important for the prosecutor to play that role at all times and make sure that the accused understands what he is being charged for and what he is also pleading guilty to. Okay, now let us carry on with our pleas and give you scenarios where the accused pleads to a charge. An accused can refuse to plead, right? If an accused refuses to plead, then the presiding officer has a duty to record a plea of not guilty, and then let the case continue. That was the case in the case of Mananyane, 1977, volume 3, SA at page 1976. 976. It's a 1977 case, volume 3, at page 976. It's at all court. So in this case, the accused refused to plead, and also in the case of Motopeng in 1965, this was I think this was if I'm not mistaken, it was a political case. Motopeng, the volume is 1965, volume 4, SA 484. You look at that case where the accused refuses to plead. Right. To insist that an accused should plead after he has informed the court that he wishes to consult a legal representative constitutes a gross departure from the established rules of procedure, and it is in conflict with fundamental rights of an accused to have legal assistance. That was what was said in the case of Mkhize, 1978, volume 2, SA at page 1065. T court. Right. Ambiguity in a plea. That's another one. Ambiguity in the plea. That now the accused is pleading guilty, but he's got excuses. He says, "I plead guilty that I beat him up, but he stabbed me first." You see now that person is actually raising some kind of a ground of justification that yes, I am pleading guilty, but he's the one who stabbed me first. So there's ambiguity in the plea, which means now this an inquiry by the presiding officer has been done to make sure that whatever plea is being tendered, the court is aware of whether the elements of that crime do exist. If there is no ground of justification, something like self-defense or anything. Right. Let us now come to the one that I asked you to research. An accused who is obstructive and rowdy in court. That accused who is busy insulting the presiding officer, insulting everyone, insulting the complainant, insulting his own legal representative, insulting everybody who's in court, including the prosecutor. So what do we do in that case? Right. If upon being required to plead, the accused does not do so directly, but he then becomes obstructive, right? He then obstructs the conduct of the proceedings of the court. The court may order him to be removed and may direct that the trial should proceed in his absence. This is in terms of section 159, subsection 1 of the Criminal Procedure Act. Let us come now to a situation as to answering a question as to when can a plea by the accused be dispensed with, right? Okay, the first instance will be where the accused refuses to plead. If an accused refuses to plead, you can see the case of Monanyane, the citation is 1977, volume 3, SA, at page 976, where the accused refuses to plead, and also the case of Motopeng. The case of Motopeng as well, it's a 1965 case, volume 4, SA at 484, where the accused refuses to plead. the presiding officer has a duty to record a plea of not guilty, right? To insist that an accused should plead after he has informed the court that he wishes to consult a legal representative constitute a gross departure from the established rules of procedure and is in conflict with the fundamental right of an accused to have a legal assistant. That was the ruling or the principle in the case of Mkhize, 1978, volume 3, SA, at page 1065. Right. Let's come now to the ambiguity of in a plea, where the accused pleads guilty to a charge, but he raises some kind of a defense or ground of justification. For instance, he says, yes, I beat him up and injured him, but he is the one who stepped me first. So in that case, also the presiding officer must record a plea of not guilty, because he's pleading guilty, but he is raising some grounds of justification. So it's not a straightforward plea of guilty. Then you record a plea of not guilty, and then you then make that inquiry to find out whether all the elements of the crime are present and whether the accused can be convicted, right, after evidence has been laid. And then let's come to that other question that I gave you, or of an obstructive and rowdy accused. If an accused becomes rowdy and disrupting the proceeding in court, it is the duty of the presiding officer to call him to order and warn him before he sends him to the cells. Because in terms of section 159 of the Criminal Procedure Act, if the accused becomes rowdy and is obstructing the court proceedings, you must first warn him and then order that he be kept in prison in the cells, that is the holding cells of the court, and tell him that the court will go on without him, and whatever is decided, he will have to abide by it. Then that's the end of it. And then you continue with the trial in his absence. Also, another scenario is where the accused is mentally ill. In that case, the presiding officer will direct that accused be taken for mental observation. In KwaZulu-Natal, there's a place called Fort Napier. He will be taken to Fort Napier for mental observation. If he is deemed fit to stand trial, he'll come and stand trial. If he is not, he'll be sent to a mental institution, and all the charges will be withdrawn. I hope you understand. I hope this makes sense to you.